Good afternoon. This is Tim Fry. I'm a healthcare partner at McGuireWoods, specializing in regulatory work, and have the pleasure of joining my colleague Jen Shanley, a digital health guru, to speak on Section 1557 non-discrimination and kind of the current status. I'll turn it to Jen in just a second, but just a bit on my background. I've kind of lived this rule since a series of rules since the Obama administration and even the enactment of Section 1557, which we'll get into in just a second. And Jen will share just a bit about her background and kind of her focus on digital health and why that might come up a little bit in today's rules and discussion.
Thanks, Tim. Hi, everybody. I'm Jen Shanley. I am also a partner in the firm's healthcare group. I'm based out of the New York office, and my practice is also focused on healthcare regulatory matters, a broad range of counseling there, including, as Tim mentioned, for purposes of today's discussion, with digital health focus. And I am very excited to be with you all today.
Thanks, Jen. So we'll get the legal disclaimer out of the way, but let me tell you what I think is probably the most important. George Bernard Shaw once said, "I learned long ago not to wrestle with pigs. You get dirty and they like it." I'm not suggesting Section 1557 is a pig. I am suggesting politics tends to be. And so if we do our job right in the next 50 minutes, I should make all of you, every single one of you, offended. I ask you not to hold that against us. This has been a bit of a political football for some of the reasons we'll talk about. We'll try to get to some of the practical implications of what you should do with the rules as well at the end. And so if you don't agree, don't necessarily take it as my view or Jen's view. We're trying to take this topic and make it come alive. So what is this topic? We kind of say the Section 1557, it's kind of become the nomenclature for healthcare non-discrimination, and it comes out of the Affordable Care Act, the law that at the time Vice President Biden called a BFD, although he didn't use the acronym, and that health reform to provide insurance coverage also contained this section. Section 1557 of the Affordable Care Act. And what you'll see here on your screen is it basically incorporates or requires existing civil rights laws. So Title VI of the Civil Rights Act, which prohibits race, color, or national origin discrimination. Title IX of the Education Amendments, that deals with sex discrimination, Age Discrimination Act that deals with age, and then the Rehabilitation Act that deals with disabilities. It doesn't, in the statute, go beyond that. It doesn't say a bunch of new things that providers need to do, insurance companies need to do. It just simply says, hey, you, healthcare, you're also subject to these civil rights laws, which was always true. But it was important to get passage back early in the Obama administration with more progressive members of the Democratic caucus that this gets said about healthcare itself. Importantly, though, it has this paragraph at the end. The Department of HHS Secretary may promulgate regulations to implement this section. And so what we're going to be talking about today is this C. How do we promulgate the prohibitions on race, color, national origin, sex, age, and disabilities? What do the regulations look like? How have those changed? Where do we stand today? So if I think about the regulations, I think about a pendulum. So kind of a theme that you're going to hear with all three rules that have been enacted so far, or promulgated so far. In 2016, the final year of the Obama administration, they put their final rule out that put the meat on that statement to avoid, national origin, color, age, sex, and disability discrimination. And in that, they started this process with kind of updating language around sex and the meaning of sex for some of the recent case law. So it included gender identity and sex stereotyping, things that the case law supported, but kind of put in regulatory language for healthcare providers and patients for the first time. It also tried to provide a single civil rights law for all discrimination claims. So a single way to do litigation, a single way that you would have to bring grievances, et cetera, tried to kind of unify each of those types of discrimination. And as a provider attorney, I think helpfully gave one set of rules instead of having to look at each of the different civil rights acts that have passed prior to that. Well, it's a pendulum. So what started out on the left has started to come back to the right. And so in 2020, again, final year of the Trump first term, OCR, the Office for Civil Rights, yes, the agency that handles HIPAA and privacy policies also handles this law, put out its version of a Section 1557 rule. It removed sexual orientation, gender identity from the definition of sex. It dealt with transgender individuals, not in the way that the left would, but some of the criticisms that come today. It did retain disability protections pretty strongly, although changed them, but added religious conscious protections. So Democrats would say that was inherent in the Obama rule and eventually in the Biden rule, but they didn't specifically name religious conscious objections because it wasn't in the statute. We're staying to those statutory cross-references. The Trump administration put in all of the various religious protections that have been passed in other laws into the regulations. It also heavily criticized the Obama administration for overreach and a lot of administrative regulatory burdens. And so the buzzword that came out of the 2016 rule that you may have heard over the last decade were taglines. You had to put taglines in all of your communications saying that you will not discriminate and use it in a bunch of different language translations. The Trump administration heavily criticized that and removed that rule. They also, because of the leadership, went to the religious piece, the changes of sex. Well, like a pendulum does, and one that is actually gathering speed, the Biden rule then took it further to the left. So they heavily criticized and said that the Trump administration gutted the Section 1557 non-discrimination rules, that they were going to make sure that care in this country is safe, culturally competent, and free from discrimination when they put their rule out in the final year of the Biden administration, 2024. And it did some things, and it's including why Jen's joining us, on artificial intelligence and patient tools, which we'll talk about. It reversed a number of the Trump administration changes, and it also, for the first time ever, applied Section 1557 and all of the civil rights laws to Medicare Part B providers. Until 2024, the federal government's position had been Medicaid, Medicare Advantage, Medicare Part A is financial assistance requiring you to follow civil rights laws. For the first time ever, Medicare Part B is included in that as well, with the Biden rule that is standing. So that kind of brings us to 2025 and some of what we're going to be talking about today. What comes next? And let's see if I can get this animation to work one more time. The swing back to the right. Now, we don't have a new rule, so some of what we're going to be talking about today is reading the tea leaves. How far are we going to see a shift back to the right? But I will tell you, this presentation was harder to prepare the last couple of weeks for Jen and I than it would have been a month and a half ago. Why? HHS has removed a lot of its website material. So following some of the early Trump administration executive orders that basically said NDEI and wokeness, etc., the Office for Civil Rights has pulled down quite a few of the materials that we would have drawn, and you see this page not found, broken links and stuff and whatnot. So we'll have a few links in this deck. I'd encourage you, if you're interested in the materials, download them as soon as possible. We did the same because it may not exist here in a couple weeks. We will see further. So today, the Trump administration, it's my understanding, will be issuing a new executive order about transgender individuals participating in women's athletics. And I don't think it'll be a surprise based on the campaign we just went through. They're not in favor of that. So if you think Section 1557, and certainly the Biden administration did, and we'll talk about, thought, we needed protections for transgender individuals, that's not going to be pushed, it doesn't appear to us, by this Office for Civil Rights. And so we're going to see that kind of shift to the right. And based on how appointments occur in the next few weeks, we will see how far to the right. And again, towards the end, we'll come back to the politics and what you need to do. So before we get into the Biden rule, I want to say a couple things. And I think it will come as no surprise to any of you that there are fights about sex. And here the cases have really pushed back against the Biden administration's definition of sex that included gender identity, it included, again, sex stereotyping, pregnancy, termination, etc. Those things have all come under a series of litigation with states suing, including the states of Florida that won in Florida federal court and got an injunction in the state of Florida. The state of Tennessee, supported by like 12 other conservative states, sued in Mississippi and got a nationwide injunction on the Biden administration's definition of sex. And the state of Texas and Montana, which sued in Texas court and also got a nationwide injunction. You see, they all happened right before Independence Day. That is not a statement about fireworks or freedom. The rule was to take effect right after the holiday. And so the injunctions took place right before that. And I apologize. I'm also not commenting about the left coast or the right coast by those states missing from my icon. I just didn't see that until it was blown up into a bigger scene. No comment about the state of Maine either. This fight over sex is long-standing. So on the left is the current regulatory language that is enjoined around what the meaning of sex is. On the right is a series of cases going back to the Obama-era rule, getting challenged on its definition of sex and having it blocked in the Franciscan Alliance case. Similarly, the Trump administration was blocked from its rules on its definition of sex from more liberal courts. They cited the Supreme Court's decision in Bostock heavily about how sexual orientation is a form of sex discrimination, to say, no, you can't take that out of the definition of sex in the regs. You can't say it isn't part of the definition of sex. And then, of course, those definitions get put in by the Biden administration, and you have the three cases. So this fight over sex has continued. It's really been part of all of these rules since the get-go and seems likely to continue with future rulemaking. So that gives you a little bit of background where we are. And as we think about how to help you all think about non-discrimination and what your requirements are, I do think it's still worth going through what the Biden rule says. And we sort of group it in 8 new regulatory requirements, which we'll go briefly through for probably the next 15 and 20 minutes before we come back to it. They're on your screen. I'm also going to show you kind of the implementation timeline where the clock icon and the Canadian maple leaf icon are existing requirements as of today. Thankfully, the tariffs were delayed 30 days, or I'm not sure we could afford that icon, but we'll, use it as long as we can. These are things you're supposed to be doing right now. You're supposed to have a Section 1557 coordinator. You're supposed to be ensuring meaningful access. We'll talk a little bit of what that means. And then we have 4 new requirements coming later this spring and summer. As long as this rule remains good law and doesn't get replaced, these are going to remain on the books as requirements. So with that, let me turn it over to Jen to talk about kind of our first area. And we had sex definition again. That's an unknown deadline. But let me turn it over to Jen to talk about our first area, kind of that meaningful access to language services.
Thanks, Tim. So as Tim mentioned, just to keep in mind too, that this is currently in effect at this time. So the rules do include protections to prevent discrimination against those with limited English proficiency. To comply with this, the entities must take reasonable steps to ensure that there's meaningful access to each individual with limited English proficiency. So what does this mean? This means that those covered entities do have to provide language assistance services. And not only do they have to provide it, there are details on how it has to be provided. It has to be provided free of charge. It has to be accurate. It has to be timely. And it has to be provided in a manner that protects both the privacy of the individual receiving the benefit of the services and also retaining the autonomous decision-making capacity of the individual receiving it. So this also says that if you're providing interpretation services, they need to be provided through a qualified interpreter. Can get into the details there, but essentially that person is able to translate effectively, accurately, and impartially in the same tone and manner and the like as intended, and to appropriately convey the contents of the message. One thing to note that there are other ways to translate to machine translations are permitted. In most cases, they must be reviewed by a human translator. That's when it gets to the text is critical to the rights, benefits, and meaningful access of the LEP, and when accuracy is essential, or when the source document or material is very complex, non-literal, very technical. So that in healthcare is going to capture a lot, right? So best practice, unless in a very narrow circumstance, it has to be reviewed by a human translator to confirm the accuracy and the like. Couple things to caution here. Patients may not, or you may not rely on patients providing their own interpreter. You cannot rely on an adult or minor who are not otherwise qualified as qualified interpreters. There are narrow exceptions to this in cases of emergency or upon the request, someone of the person with limited English proficiency may ask for interpretive services through an adult who is not otherwise deemed qualified, but then there are additional mechanisms. It needs to be a temporary measure, documented, gets complicated there. So the general practices must always be provided through a qualified interpreter. The other thing too is it may be provided through video or audio interpreting services. Note though that if provided through those means, do have an obligation to ensure that it remains meaningful access. So making sure connections are good, that the service that you provide is going to be reliable, and use reasonable efforts to make sure that that is the case. So here's a hypothetical that we put out for you. We've taken this, as Tim mentioned before, there has been guidance that was previously available on OCR website links. This was one of those that was previously available. It was published during the Biden administration. It gives illustrative examples of how this concept and this requirement applies in the telehealth context, and makes it clear, if not already, that limited English proficiency access requirements also apply to those providing telehealth services. So in this hypothetical, it's a federally assisted healthcare provider who selects a telehealth platform. But unfortunately, the telehealth provider does not make sure that the platform can support the inclusion of interpreter services, either through the telephone or video. Turns out the platform could not provide that capability as part of the services of the call. Stop. This could be discrimination against an individual with limited English proficiency because, again, as mentioned, needs to be provided in a non-discriminatory way and needs to make sure that the provider can effectively communicate during all aspects of care to the individual receiving the services. So here, there was no reasonable effort taken, and that could create risk from a discrimination perspective. Another area that the Section 1557 and the Biden rules include protections to prevent discrimination against those with disabilities. Again, these are currently in effect and compliance is required at this time. Here, the standard is making sure that the communication is as effective as communication with those with non-disabilities. This requires reasonable modifications to be made to ensure that compliance with this effective communication standard. Now, this can be met, and certain accommodations may be providing appropriate auxiliary aids and services. If that is necessary, they need to be provided free of charge and in a timely manner as well, too. Think there's certain examples of what these aids and services may include, which may include sign language interpreters. Again, need to make sure that there are responsible and efforts taken here to make sure that it's available. And similar to the interpreters, need to make sure that sign language interpreters are qualified. No surprise here, other examples too, maybe if blind, provided in Braille, screen readers, large text, etc. There are reasonable ways and accommodations that could be provided to ensure that, again, the communication is just as effective as being provided to someone without disabilities. Also highlighting here that there needs to be accessibility to the physical locations of where it's providing, a little less so in telehealth, but in general too, to note that. And for telehealth purposes, technology, same thing, reasonable access to the website, to the portal and the like. So again, maybe having it in big lettering and the like. I can give you another hypothetical here. Again, this was also taken from the guidance that was previously available on OCR's website. A physician's office offers additional time in advance of an appointment to give a patient with an intellectual disability a chance to become familiar with the features of a telehealth platform. So during the visit, the provider speaks directly to the patient about their care, taking additional time as needed to ensure that the person understands what is being asked. The provider also uses a platform that allows a support person to be present with the patient or log in from a third location. These are examples of reasonable modifications that the provider implemented into their practices in an effort to ensure that the communication is just as effective as being provided to someone without the disability. A couple things to note here, communications, the needs may differ based on the specifics of the individual and their specific disability. So there is no one size effective solution that's going to cover each scenario. Again, taking a reasonable approach here. Here, just highlighting, not going to go into detail in each one of these, but there has been previous enforcement activity for failing to provide interpreter services or denying a request for interpreter services and the like. And the penalties have ranged from corrective action, significant corrective action, to also fines and monetary penalties as well. So we highlight these, but also keep in mind that there could be additional ones in the future, and this is something to be monitoring. With that, I'm going to hand it back to Tim to run through some of the additional protections and requirements.
Thanks, Jen. So a third one that's also in effect today is y'all need a Section 1557 coordinator. If we were in a room, I'd ask for a show of hands to ask how many of you have a Section 1557 coordinator. If healthcare due diligence is any indication, the answer is pretty low. But this is something that needs to be in place and required. The Obama rule had a different name for these. The Trump administration deemed this to be extra regulatory burden and got rid of it. It has come back. For our recommendation is make sure you name somebody in writing, just have a consent there, and then educate that person that they've been named, that they know what that means. And we have on the screen a few of the things it requires. But you do not need to go hire someone for this. This does not need to be someone's full-time job. It's often housed within human resources, especially if you have a good staff there where they may be used to employment discrimination. Healthcare patient discrimination is a little different, but if they have the good background, that's often a good person. And of course, compliance officers or your compliance department often house this as well. It's totally fine for you to put this under your chief compliance officer, and do not hire someone else for this, but make sure you've named them and done some of the things the rules require. And then the last of the in effect rules, you need to provide patients a notice that you will not discriminate against them. And this page has some of the required consents and notices that are on this. I mean, it should say notices. I apologize for it saying consents. And you need to provide it annually upon request on your website. If applicable means if you have a website, since those of you on the phone have a website, it needs to be there. And it needs to be posted in your physical office locations. Thankfully, OCR has this, and they've actually translated it to 47 languages. As of last week, as we were finalizing slides, this is still available for now on the OCR's website. So you can feel free to download it, or if you get our slides, you can copy and paste, and we can obviously send you a Word document as well. One thing I'll notice, and this goes to, I think, the Trump team's critique of over regulatory burdens, needs to be at least 20-point font, which our picture here on the screen is not. That's not 20-point font, so it has to be bigger. And it needs to be with sans serif fonts, which I always have to remind myself, and before I did this again, just remind myself, those little fancy little loops at the end of font, like Times New Roman, can't use that. You have to use Arial or Verdana. I don't know what Aptos, the new font from Microsoft, if that's sans serif or serif, but you have to worry about those things. It's part of the reason I would expect, as we get to practical next steps, this probably will be pulled, but right now it's still good law that you need to be providing this notice to all your patients. Jen, do you also want to take us through kind of what's coming later this spring on patient care decision tools?
Yes, happy to. So this is one that the deadline it has not been triggered yet. It's May 1st, 2025 of this year. But this is a requirement that prohibits providers from discriminating through their use of patient care decision support tools. And that's a defined term. It's intentionally broad. It covers many different tools and modalities, everything from flowcharts, paper flowcharts, to very complex AI tools. But the crux of it is it's a tool that is used to help make patient care decisions. But this covers everything from screening, risk prediction, obviously diagnosis, prognosis, treatment planning, et cetera. So it does cover a large array of uses there. Now, once there is a patient care decisions support tool that you're using, you're required to, one, take reasonable efforts to identify those support tools that risk discrimination. The rule doesn't prescribe any specific steps that you have to take. That's just the standard, that you take reasonable efforts to identify tools that risk discrimination. But there are examples that they give that give a little bit of illustration here. You could, one, identifying categories that are identified for high risk for discrimination. So if you're aware that heart failure or other particular conditions and uses are at a higher risk, then you want to make that known and dig in deeper there. Want to research reliable industry articles. This will help. It's kind of a correlation to number one there. This will help you identify those uses or those scenarios that could result in a high risk of discrimination. Third, you can obtain information from the tool vendors. If this is an external developed tool, ask the vendor, are there limitations? What is the input? There is a higher risk if the tool that is deployed has race and other identifying features and characteristics that are input into the tool that may affect the outcome that the tool provides. The determination of whether a provider acted reasonably is going to be made currently on a case-by-case basis. Things that are going to be factored into the analysis are, and again, these are just examples, non-exhaustive, but the size and resources of the entity. The information that was available to the entity at the time of the use, understanding that developments may be made and the like, right? But what was known to the provider when using it at the time of, whether it was used as it was intended, whether if it is an approved medical device that it's used, was it used in accordance with the label, with the limitations there? Did the provider make any subsequent customizations, personalize it, or just use it not as it was intended to use? Another one was whether there was a process in place to evaluate. So even taking the efforts to see if they're at risk, and even if not, ultimately coming to the same conclusion, did it go through that effort? Those are different determinations and factors that may be analyzed when determining whether a provider acted reasonably in identifying a tool that could risk discrimination. For those tools that the provider has identified has that risk, those providers then must subsequently take reasonable efforts to mitigate the risk. Again, no specific actions are required or prescribed, but examples were provided. So policies and procedures regarding the appropriate use. So having it documented that the workforce needs to comply with of what is appropriate use of these tools. Ongoing monitoring of the tool's use and reviewing, having a process to collect complaints, review the complaints, and potentially address the complaints. Having that in place will help demonstrate that a provider took reasonable steps to mitigate the risk. Other examples are, is there a human in the loop? If the output is reviewed by a qualified healthcare provider who either agrees or disagrees with the tool's determination, that will also help reduce the risk. Staff training on appropriate use and limitations. So were the staff made aware that this tool has restrictions, has the ability to result in a discriminatory application? This can make them more aware of potential limitations here and help inform their responsible use and deployment of the tool. Again, this is a case-by-case review standard, but those were some illustrative examples. Continuing in the vein of illustrative examples, here is a hypothetical that we took from a Dear Colleague letter that was issued by the OCR last month. And this hypothetical lifted right from there says a practice uses a pulse oximeter in its practice and in treating patients. The practice has not considered if such equipment could be discriminatory. Staff has not been trained on different readings for patients of color as compared to patients with lighter skin. For example, the provider has not considered that public studies have not suggested additional indicators of respiratory stress are necessary to ensure appropriate care for persons of color beyond oxygen levels. The practice has not audited this tool or identified any potential risk. You can probably see where we're going on this one, the suspense here, but yes, proceed with caution because this tool could result in discriminatory deployment and could risk discrimination if not appropriately mitigated. So this hypothetical shows the importance of taking reasonable steps to identify a tool that could be discriminatory. Here, they did not check the articles that were available to them that would have alerted to them of this risk. And then they also did not take reasonable mitigation steps like training the staff on the limitations. And they did not audit the tool's deployment. So based on this, when the factors at hand, likely that would present the risk of being deployed in a discriminatory manner, potentially. So started off by this subsection by saying that this covers a broad array of tools. Again, everything from flowcharts, but to very complex AI and really any form of AI that does have that decision-making element. The image on the right here is actually that dear colleague letter that I referenced that hypothetical was lifted right from. On the left, this is a bipartisan report that was issued at the end of last year. This report covered a wide array of views, nothing really groundbreaking here, other than that it does seem reflective of a bipartisan support to find that balance. Recommendations out of the report for healthcare was really focusing on making sure that the data input is of high quality. Junk in leads to junk out. So really making sure that the data is reliable, that is being used to train the data, that it's not being informed by only a narrow subset of patients that are going to be much narrower than it's going to be applied to. Those types of factors are something that we want to consider. And then ongoing monitoring was another theme here too, is to make sure, particularly in AI that may evolve, right? That its continued use is being monitored and the provider is in a position to respond to those monitoring. If it identifies a concern, be positioned to identify it and address it. But here again, do flag, this is a developing area, and here in particular would recommend staying abreast of the updates here. I'll hand it back to Tim.
Thanks, Jen. And I think it's so interesting because if you read all the stuff when this first came out, is the view of like this is just about technology, but I think the pulse oximeter example shows something that many of us get every time we go to a doctor could be put in. So just a couple, and we're going to go through it pretty quick because we want to get to then kind of some of the practical takeaways. But for the Biden rule for the first time would require non-discrimination policies, not just a notice of non-discrimination, but an actual policy on this, as well as 4 specific procedures. And I have that on the next slide, as well as the link, which is still available, at least it was as of Sunday, to pull down their default non-discrimination policy, effective communication procedures, language access procedures, reasonable modification procedures, and grievance procedures. So by the summer, you're supposed to have all 5, and they are available on the website. Around that same time, just after July 4th, you're also supposed to start giving notice of language assistance services and auxiliary aids to all patients. This is what was known during the Obama administration as taglines. Again, we need sans serif, no squiggles, 20 or more size font. I think most people, if they do all this, will put the notice of availability right in the non-discrimination notice. The Obama administration had a whole ton of rules around needing to put it in all your communications. The Biden administration's a little bit more wishy-washy. They've given examples of where the notice could maybe apply, but I think candidly, if it's on the website, you give it annually, it's part of your notice of non-discrimination. Think about whether it's worth doing it for things like bills or No Surprises Act or one of these other things. You can kind of consider whether they need to be notified that there's a translator, but there's a little bit more wiggle room than there was during the Obama administration's rule. And then again, coming this summer, assuming the rule doesn't you have other issues before then, there is a Section 1557 training that will be required of all the staff and employees that you work with on your policies and procedures. There are some training materials on HHS's website, but you need to tailor it to any changes you make to your policy, and those training materials might not last. If you borrow our slides after this as well, maybe that's the base of it. Consider putting it on your own logo and letterhead for your employees, but you're supposed to do that and have all employees trained. We would also recommend doing it at least every few years periodically. But the rule itself just requires every time you make a material change to your policy, you would need to retrain the staff. So those are kind of the 8 requirements. What comes next? Does the pendulum kind of stop where I had it at the get-go of just a few balls, or does it go all the way further to the right? And, I don't know for sure, obviously. We're trying to read some tea leaves. But I think some of the work of, the first 3 weeks of the Trump administration is very suggestive with their executive orders. We have a few on here, defending women from gender ideology, extremism, ending DEI programs. There has been executive orders on restoring biological truth to the federal government, that it's the policy of the U.S. that there are 2 sexes, men and women, that is very suggestive, particularly around the definition of sex that the courts have blocked, that this administration is not going to follow the Biden administration. Probably not a surprise, but let's state that. But I think the DEI pieces, things around declarations that we want to end indoctrination of our children on race ideologies, as well as gender identity, is very suggestive that some of the heightened concerns around race is probably going to be less so. But I think because of this emphasis on sex, you could see OCR, the Trump administration OCR, making some really strong pushes around sex discrimination that involves a traditional woman. I won't make the too much of things, but the kind of more, it's not necessarily the trad wife, meme on social media, but more of kind of the traditional historic definition of woman will maybe be protected by OCR. I think you can see some strong hints of that. I also think, these executive orders and, kind of the Trump administration's campaign around immigration is highly suggestive of what they might do to some of the language rules that we went through as well. While there's still good law, that's not something that's going to be a focus of OCR. We can also look back to the Trump administration's rule and think in terms of themes of 8. That's how much we can fit on a slide, apparently. These are kind of 8 of the big changes in the 2020 rule. So changes to the definition of sex, I think clearly is going to happen if and when they release a new Section 1557 rule. And in the meantime, certainly I don't think OCR is going to be enforcing those rules because they can't. The courts have blocked OCR from enforcing Biden's definition of sex. That block continues, and certainly I expect the regs will change if and when they change it. They eliminated the notice and tagline requirements. So those things about notice, those things about kind of letting people know in writing that you have translation services available, probably going to get blocked again. The Trump administration added religious conscience-based objections, not one of the cross-listed statutes in the Affordable Care Act, but they specifically named certain religious freedom laws that the Biden team took out, saying, look, the rules that Obama passed, that we're passing, we're promulgating, they already say it has to adhere to all other federal law. That would obviously include religious freedom. It's not in the statute, so therefore we're not going to talk about it. That obviously didn't stop the Trump administration from issuing those rules. And if they issue rules, I think religious discrimination is going to be back. And in fact, you see one of the first things this OCR is doing that they've announced they're going to go after 4 medical schools for certain anti-Semitic kind of pro-Palestine protests that took place on campuses last year. That's where OCR is going to be spending some of its efforts. So I think religious discrimination you can kind of take back from the 2020 rule and look at things. And you'll see some other things in terms of reducing technical requirements, giving providers a 4-factor analysis to consider if they need to make things like translators available. I think you're going to see some additional flexibility, and I think you can look at the 2020 rule as that for guidance. And so as Jen and I talked about this and we put it all together, how can we give you some practical guidance in that swing to the right? And, first thing I say is, assuming we have a Democratic administration in the future, expect this to swing back to the left. And so if you've already implemented some of these things and you've implemented notices and policies and you're training your staff, maybe continue doing it. No need to kind of follow this pendulum back and forth. Maybe someday we get to a homeostasis, but until then, if you're already doing some of this stuff, or if some of the things you heard about today and it's good regs for now, you say, let's go ahead and implement it, then we know we're adhering to law. Well, leave it in place for these next 4 years, and in 8 or whatever it is, eventually you might see kind of a return to the left. This pendulum might keep swinging. I'd avoid using language like diversity, equity, or inclusion. In adherence to federal civil rights laws is a fine focus. I would use language like that. DEI is certainly an acronym that I think people are going to be worried about. The federal civil rights laws that have been cross-referenced in Section 1557, they're all still protections for these classes of individuals. And you can be sued under all these laws. If you kind of say, I'm glad in the first Trump administration they got rid of notices, I expect they will again. I don't expect they'll enforce the Biden administration notice requirements. I probably agree with all of that, except you can get sued under the Rehab Act for not providing notices. And so that's where some of the kind of these laws, the regs on Section 1557, are a little bit helpful of kind of bringing that all together for a provider. So just be aware of that. You still have some of these requirements, and they're a little bit harder to track down because they're in different things. They deal with both education and healthcare. So even if we see that kind of shift to the right, some of this guidance might be helpful still because it helps you with other things. But I think the key thing I'd say is disability rights stayed important during the Trump administration's enforcement actions. I would fully expect that to be the case for this OCR as well. Whether it's, whatever you think of it in choices of classes, conservatives, Republicans have often been champions on disability rights as well, or if you don't want to call them champions, at least have supported those. I think OCR will continue to focus there. We've mentioned protection of, kind of traditional women. I think, they may bring some pretty high profile sex discrimination cases against, women, qua woman, because they want to make sure they make an efforts around there. And then I'd expect religious conscientious objection things as well. You can look at some of the early things like reinstating everyone in the military that refused a vaccine back into the military, or at least getting rid of their discharge. I think you're going to see some of that and giving people a chance to say, my faith is more important than some of these other issues. And I think OCR will be supportive of that. So those are kind of three areas I think you can expect to see OCR focus. And then the last thing at the federal level I'll say is these notice requirements require it on your website. Websites remain public. They're easily checked, except when the links are broken. So I've always thought one of the things our clients should do is let's get the non-discrimination policy on your website. Put it a link on the bottom of your footer of your first page. Maybe people will check it, maybe they won't. It certainly will be there for due diligence in the future. And now it's not as easily checked some of the other types of discrimination that, yes, are more problematic, but a lot harder to check. So get your website up to date. And then the last thing I'll note, states have their own requirements. And I don't know, Jen, if you want to share anything about New York's rules, but since you sit in New York City, but New York has rules. California has like 300 some rules on language access. Every state in the country has a rule about language access. Some of the things around transgender and sex vary state to state. So think about that as well. Sorry, Jen, I invited your comments and then I kept going. So I'm sorry about that.
No problem there. No, and there just to look at state requirements too. For example, with New York, they have in the hospital patient bill of rights a requirement that you provide those language interpretive services and the like too. So you may have to, they might be narrow, they may be broad, but each state you want to be mindful of that and take a look as well too.
Thank you, Jen. So we'll put our contact information up. We're approaching the hour. We've been trying to respond to some of the questions that came in by text. If we didn't get to your question, or we'll follow up. If you weren't satisfied with the written answer I gave you, please just send Jen or I a note. We'd be happy to connect here or on LinkedIn, and really hope that you have a chance to interact with us in the future. And if you have questions coming out of this, don't hesitate to reach out. I will note 2 invitations for you. For those of you in the Nashville area, we'll be in Nashville for our healthcare pop-up in 2 weeks. If you haven't gotten the invitation to that, please reach out to me and my assistant will make sure you get invited. It's a great event for healthcare investors. It's corresponding with the Vive event, so we'd love to have you there and meet you in person. And then coming up in May in Chicago, our annual healthcare private equity event for the 21st year, the second or third in a warmer month for y'all from the South. And we'd love to have you there. We'll have, 1,000, 1,100 attendees talking about various things focused on healthcare and investors in the space. And we'd love to have you there and continue these conversations.